This is Lions Park, and this is the location where they have the, of course, the Rotary Club sits here and monopolize and works with the community, providing services for Evergreen Implement, John Deere Evergreen, which is the stage. Vendors come here and put their vehicles or vendors, and they come to City Hall at 500, talking to Yvonne Hernandez and also Bonnie, and getting their vending spot, just like Simon's Mall. We rent out the property for $1,000 a month, and just like the vendors here, they rent out the property, the lot, the area, and they got a section area to deal with, compete against, of course, that would be the Rotary Club. And the Rotary Club does have their, we got pancakes, we got biscuits and gravy, we got syrup, maple syrup from fresh honey, and this fresh honey from the bees from Sunny Farms are activated and cultivated. This is the Rotary Club location. Now the Rotary Club has all the inlets, outlets, and are connected to Vista Utility. The Vista Utility is connected to their services, and they got the meter, the gauges, the switches where they can connect the outlets. And that's Mr. Jim Logan. Jim Logan got his Rotary Club. He's at 745 11th Street, Harper Castle. And then we have the meters that are placed in for the vendors so they can calculate the data. All the calculated usage of the kilowatts and the donuts and the placements are placed on T20s. So don't overly extract or take any money from the Vista Utilities here in Spokane, or the nuclear power containment units, and also the regular magnetic turbines that are collecting all the data information on their services. And this is pretty much this is the barbecue, which is right next to the Rotary Club where they park here. Now the Rotary Club here at 1005 East Ham, that's Jim Logan, Mayor of Othello, and that service is here at 645, so that's Jim Logan. We got the they got the kayaks and the aquatic center, the Gold's Gym, Mrs. Rozzy, who has her picture on the wall at the Gold's Gym, and their services for the cardiovascular program, the Queen's Gate, the Backyard, Badger Mountain, which is Andy Miller at CO Benton, Washington. That's Andy Miller, prosecutor. He exercises in Richland, past Kennewick. There's the Blue Bridge, the Cable Bridge, the Green Bridge, the Cable Bridge, the Blue Bridge, and also the Pasco and Richland Bridge. And that's connected. Those services connect. You can run, exercise, and you also can run from Bateman Island. Also, the services they have at Bateman Island, where it used to be old Chuck E. Cheese and Smorgies Buffet at Bateman Island. But this fence line they have here, all the vendors come in here from Pasco, Kennewick, Richland, Pasco, Kennewick, Yakima, Spokane, Seattle, Tacoma. They come here and sell. Now, Space Burger, it's not Space Burger, it's Top Burger. Top Burger, we competed against, Rotary Club competed against, Top Burger sold all burgers to Othello, Washington Lions Park. Here at the playground and also the basketball facility, we have the championship for the basketball, and then championship for the girls, the Girl Scouts and the Boy Scouts and the Girl Scout, the Brownies. The boys and girls, there's a flag staff here in Lions Park. Right, Lions Park is Lions apartment complex, and then Western Inn, and then Time Out Pizza. See, we have Oompa Bank, U.S. Bank, Chase Bank, Columbia Bank, and they also have Country Financial, and they also have Safeco, and that's Mr. Jim Logan. Carper Carousel, and also the mall, which is now 24-hour fitness, and the laundromat, and Sears, and used to be called Safeco. Long time ago. Now it's called Base Insurance Company. But Safeco was part of the Studio 7 and Cruiser Academy, Department of Motor Vehicles, Melissa McKnight, Mrs. Vasquez, and Freda, and also Moslick Washington. Also the agency abstract record for your record and also your services, which was Carol J. Benzel, the judge here in District Court. Now in District Court they have Mrs. Carol J. Benzel. Phone number is 509-735-3591. She has a track record here. She has recollection reports on everything. How many times you've been pulled over? How many times you've been sent to DWI vocational schools for drinking and driving, rehab? How many times you've been behind the wheel? How many times you driving on a suspended license? How many times you've been... See, Department of License does that. And they have a extensive record on all the reports. Election law. Democrat Executive Committee of Florida versus Lee, Civil Rights, Constitutional Law, Election Law, U.S. Court of Appeals for 11th Circuit. Independent Party of CT State Central versus Merle, Civil Procedure Election Law. Independent Party of C State Central versus Merle, Civil Procedure Election Law, Constitutional Supreme Court. Independent Party of CT State Central versus Merle, Court, Cincinnati Supreme Court, docket SC 20160, February 19, 2008, Richard A. Robertson. Areas Law, Civil Procedure, Election Law. This is an independent party. CT State Central versus Merle, Court, Cincinnati Supreme Court, docket SC 20160, February 19, 2019, Richard A. Robertson. Supreme Court District Court dismissed the writ of the plaintiff. Brought to the plaintiffs in the air of seek and protect their rights to respect a judgment of trials court of challenging appeal independent party of CT State Central versus Merle, AD 3D CONN 2000, holding the writ of error was moot. Its judgment in the trial resolved the dispute between the Danbury and Waterbury factions of state independent party by granting dictionary injunction relief to directing Secretary of State Denise W. Merle contempt to endorse as made pursuit in party's 2008 bylaws. The faction of the State Independent Party of granted dictionary injunction relief directing Secretary of State Denise W. Merle accepting only those endorsements made pursuant to party's 2010 bylaws. Plaintiffs wherein 13 candidates were the state of House of Representatives endorsed Danbury's faction prior to court decision. Endorsing candidate argued the writ was moot because Secretary on challenging decision accepting Danbury's factions endorsement in respect of 12 of them. The Supreme Court dismissed this action, holding one writ of error of moot. The defendant of various separate requests relief was not properly before the court. Independent Party of CT State Central versus Merle. Court Cincinnati Supreme Court, docket SC 201165, February 19, 2019, Judge Richard A. Robertson, Area Law, Civil Procedures of Election Law. The Supreme Court affirmed the judgment of the trial court of defendants of Michael Tiska of Rocco Frank Jr. in the battle between of Danbury faction of Waterbury faction over the control of the state of an independent party, holding the trial court decision of timely that the trial court construed on general laws of 9374. In this decision, the trial court ordered Secretary of State Denise W. Merle accept candidates' endorsement made in pursuit of 2008 bylaws, independent party, CT State Central, which together which its officers led Danbury faction filed complaints, which the effect gave Waterbury faction control over independent party state nomination. Supreme Court affirmed holding one. Trial courts ordered a supplement briefing or argument concerning a subject matter jurisdiction, preserved its personal and jurisdiction parties, stopping later, restarting decision period, and rendering report decision timely. The trial court properly determined section 9374 rendered 2008 bylaws, controlling opposing bylaws, Danbury faction by previously filed with the Secretary. Idaho Supreme Court subpoena. There's a C3 Enterprise versus Safeguard Business System, docket 45093. This is February 21st, 2019. Judge Roger S. Burdick. Operation Meditation Business Law and Law and Contracts. 2008 T3 Enterprise Independent Distributor Agreement with Safeguard Business Systems, SBS 2014. T3 filed suit against SBS had breached and distributed agreement failing to prevent SBS on distributing failing for T3 consumers. And these customers are paying commissions for interfering distributors rather than T3. Distributor agreement between SB3 T3 contained arbitration clause indicating disputes mostly resolved in Dallas, Texas, based on operating procedure. Distributor agreement contained a former selection clause indicating the Federal Arbitration Act (FAA) Texas law would apply May disputes between parties pursuant to agreements. SBS moved district court and appealed arbitration in Dallas. District court determined parties submit arbitration, but Dallas form selection clauses unenforceable arbitration was take place in Idaho. The panel found in T3 in District Court confirmed the award count amount of $4,362,441.95. District Court denied SBS motion to vacate, modify award. SBS applied, finding that reversal error in Idaho Supreme Court from District Court. Mulberry versus Burns Concrete, docket 45184, February 21st, 2019. Judge Roger S. Burdick, Area Law, Civil Procedure, Real Estate Law. Now, Burns Concrete Inc., Canyon Cove Development Company, LLP, Canyon Cove Appeal District Court, judgment in favor of Nora Mulberry. See the background, that's the mayor's house. It's Sean Logan's house in the background. As you can see, this is February 22nd, 2020, here in Othello, Washington. This is Sean Logan's house. This is the the Rotor Club area. And the Rotor Club area, that's Jim Logan. Sean Logan, of course. We got breakfast, we got parfaits, we got systems, we got honey from Sunny Farms here in Othello, Washington, Highway 17 that connects to I-90, Highway 2624, Sun Acres, Sunny Farms, Cimaron 59C, the insurance company, which should be, and also Carper Carousel is Jim Logan. See, there's two kayaks in the back garage area, and those kayaks are used for Calabasas programs, cross-training programs, long distance running, and there's also continuous bench pressing, continuous dumbbell curls, dumbbell bench press, flat bench, dumbbell press with the 5s, 10s, 15, 20s, 25, 30s, 35s, 40s, 50s, 60s, 60s. See the 10s, the 5s, 10s. You're going to do flies, of course, with these. Dumbbell press, inclines, declines, flat bench, and also declines, inclines, and flat bench. There's the 45, 50-pound Olympic bar. There's the cross training. You can run all the way to I-90 on Potato, all the way to the LDS Church, which is the Latter Day Saints, and also the Vice President and President's office, to Pasco, Kennewick, Richland. There's the Seattle area. There's also the Gage Boulevard, which is LDS, for the tithing. And there's services they provide for their endowments. And there's Melchizedek priesthood. These priesthoods and also abbreviations like catechism in Catholic churches, or any of the single awards or marriage certificates they continue on, these services are applied. Now this is, let's get adjusted here. A little light on the subject. This is Marbury Burns Concrete, docket 45184, opinion date February 24, 2008. Judge Roger S. Burdick, Areas of Law, Civil Procedure, Real Estate, Property Law. Burns Concrete, LLC, Canyon Cove Development Company, LLC. Canyon Cove applied district court judgment in favor of Nora Mulberry at TN Properties, LLC, Collective Mulberry, regarding engagement of right of first refusal, ROFR, 1999. Nora and Thordale Mulberry sold a piece of real property to Canyon Cove and included a ROFR, nearby distinct parcel and real property of ROFR property. 12 days later, Canyon Cove conveyed its interest in both the purchased property and ROFR. Burns Concrete recorded the deed to purchase property of Bonneville County, Idaho recorder in 2000. Nora Mulberry and her husband, now deceased, conveyed the RFA property of their wholly owned limited liability company. TN Properties simply recorded a deed with the Bonneville County Recorder of 2008. Mulberry filed complaint seeking discretionary judgment and subsequent motion of partial summary judgment. The district court encouraged partial summary judgment in favor of Mulberry, finding ROFR personal Mulberry Canyon Cove. It was subsequently extinguished. The Canyon Cove assigned its Burns Concrete reconsideration. District court held in ROFR was substituted abundant purchased property and reaffirmed it. Was extinguished by Canyon Cove convenes Burns Concrete. Burns Concrete Canyon Cove timely appealed this Idaho Supreme Court. Reverse remand filed. Number 1, RFR was personal to the parties, thus assigned to RFR extinguished when Canyon Cove purported to assign Burns Concrete. Therefore, the district court erred, ruled RFR extinguished Canyon Grove appropriately assigned to Burns Concrete. Matter remand for the determination of other issues raised in complaint that they were previously dismissed as moot. Court. This is Montana Supreme Court. This is RAS citation 2019 MT47, February 21st, 2019. Judge Sanford. Aries Law, Family Law, Native American Law. Supreme Court affirmative the judgment of District Court terminating mother's personal rights to her minor children for failure to comply with the reunification-oriented treatment plan. Only District Court's failure to comply determined whether children were Indian children before terminating mother's parental rights as harmless. On appeal, mother asserted that the District Court abused discretion in failing to propel, confirm, dispel reason to know that children were Indian children as defined as Federal Indian Child Welfare Act 25 U.S.C. 1901. Supreme Court affirmed holding the light of a subsequent and conclusive tribal determination whether a child was eligible in tribal enrollment abuse discretion in failing to comply with 25 U.S.C. 1912, 25 CFR 23107, 23.108 was harmless. This is Smith versus Tilton County Board of Education, U.S. Courts Appeal for the 6th Circuit, 185426, February 21st, 2019. Judge Gibbons, Public Benefits Tax Law. Murdoch, an employee of the Tipton County Board of Education, received an email reporting to the Dr. Bibb, Director of Tipton County Schools, requesting 2000 employee W-2 tax information. Murdoch responded document contain information from W-2 for every board employee, include names, addresses, social security numbers, include information, deductions, exemptions, withholdings, tax payments. Taxpayer identifying number of Murdoch learned about the Bibb. Had not requests for information, Tipton County Sheriff notified the U.S. Secret Service Internal Ravine Service. The board notification employees intervened, released Smith, and board employees filed suit under 26 U.S.C. 6103 and 7431. Section 6103, the Internal Revenue Code prohibits a local agency information program listed, and 61031-7D. For disclosing return information, Smith argues that because the board works Tennessee State Board of Education to administer a national school lunch program, the board provides a qualifying SNAP benefit. 6th Circuit affirmed dismissal of suit, finding the board does not administer SNAP benefit providing lunches to students as part of national school lunch program. This is Alaska versus Planned Parenthood of Great Northwest. Alaska Supreme Court, docket S16123, February 15, 2019. Judge Carney. Area Law, Civil Procedure, Correctional Law, Government Administrative Law, Health Law, Public Benefits. 2014 Statute 2013 Regulation redefine their arbitrations are qualified as medical necessary for purpose Medicaid funding. The statute defined medical necessary arbitrations. As those must perform to avoid the treatment of serious risk of life, physical health, and human from continuous human pregnancy as a result of number of listed medical conditions, regulations, and summary restriction plan. Parenthood Great Northwest challenged both statutes and regulations unconstitutional. The Superior Court held on both measures violate Equal Protection Clause of Alaska Constitution. Reason for the measures imposed of high risk, high hazard standard abortion funding unique among Medicaid services, and held 2001 decisions striking down neither abortion subject restriction equal protection grounds compelled the same result. The state appealed, arguing the statute regulation should be interpreted independently, Therefore, violating Alaskan Constitution equals Protection Clause. Alaska Supreme Court affirmed the Supreme Court decision state that regulates facility different treatment of pregnant women based upon exercise of reproductive choice required court appeal scrutiny, and the proposed jurisdiction funding restrictions did not withstand such. Supreme Forum Supervision. The statute of regulation facility different treatment regulates women based upon their exercise of reproductive choice required court applied strict scrutiny, and proposed jurisdiction funding restrictions did not withstand such exacting examination. Wisconsin Supreme Court. Steadfast Insurance Company versus Greenwich Insurance Company. Docket 2016 AP001631. January 25th, 2019. Patient D. Randsack. Every law, insurance law. Supreme Court affirmative. The part of a reverse part of the decision of the Court of Appeals affirmed the Circuit Court grant summary judgment to the Steadfast Insurance Company, giving Steadfast the right recovery. Greenwich Insurance holding, among others, Greenwich breached defense from the Greenwich based on insurance relationship. Now, this insurance company got now where the officers attacked me at 1344 East Main Street on December 3rd, 2018. That's Mr. Hansen. Now, the State Patrol units are contacted. This is Mr. Sean Logan's administration address at 1005 East Main Street, Othello, Washington. We have the individual officer harassing and starting problems at crossing the street. And starting problems and confrontations every time he comes around. Since we're at Sunny Farms, we got the, of course, administration office, City Hall, and agencies involved because the insurance company where the officer across the street, and across the street again, he's starting problems again. Same officer, tasing, intimidation, threatening nurses inside the hospital at night, but at day, the chief accountant here at the hospital got all the information downloaded. Since and submitted all the information down, we have the correct address, which is accurate to the T. And this is Sean Logan's Austin. This is Jim Logan, Carpenter Counsel Administration, Mr. Don Logan Services, Mr. Jim Logan, Carpenter Counsel with the Administration Office. We're having YouTube, Facebook. This is Steady Fish Insurance Company, Greenwich Insurance Company. This is Docket 2016 AP001631, January 25th, 2019. Judge Patience D. Randsack, Areas Law, Insurance Law. Based on Supreme Court firm reversed this part decision in court affirmed Circuit Court, Grant County. And this is 210 West Broadway, P.O. Box 187, Ritzville, Washington. Carol J. Benzel, 509-488-3935, 425 East District Court, Othello District Court, 425. That's 425 East Main Street, Station 400, Othello, Washington 99344. Now, the Supreme Court affirmed reversed the decision in Judge Appeals. Grant summary judgment. This is online. Steadfast Insurance, Steadfast Right Recovery, Greenwich Insurance Company. Holdings among these things. Greenwich breach the duty to defend to certify the recovery from the Greenwich-based insurance relationship. Milwaukee Metropolitan Sewer District, MMSD, were sued the alleged maintenance operation of Milwaukee sewer system. And deterrent defense insurance steady accepting the tender of Greenwich, a steady effect Greenwich recovery defense paid on MMSD. Supreme Court held on both Greenwich steady fair primary successful insurance regarding MMSD Greenwich breach conclude duty defend MMSD. State concurs to defend MMSD Greenwich concur duty defend MMSD and therefore costs of lucrative between steady fast Greenwich steady entitled recovery attorney fee from Greenwich. That's coming to you live. Sean Logan's house, mayor of Othello, Washington. And this is February 22nd, 2020 at 6:09 p.m. This is Sunny Farms. Coming to you live. It's all downloaded. Sunny Farms here on Highway 17 and Grant County, Moses Lake, and also the demonstration here in Othello, Washington. And also this is City Lions Park. And this is Sean Logan's 1005. Jim Logan, 645 11th Street.